Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Joining me once again, always Jesse Barrientes, the co-host.
Hey Dave, how you doing?
I'm doing good. We're going to cover a few different topics today. We're going to move it around a little bit. We've got some bankruptcy questions, some divorce questions, a little bit of probate. So let's fire right off the bat. There's been some changes in the last couple years with regard to divorce, but the main constant thing is you still have to either agree to a settlement or it's going to go to a trial, correct?
That's true. Those are really the only choices. If you agree, it's better to agree to have some control over what you're going to agree to than to have a judge who is going to look at a thumbnail sketch of your life, make a decision that neither party is going to like. In fact, that's what we always say. If neither party likes the decision, it's a good decision. But a lot of times one party doesn't like it more than the other party.
Right. A change is not always good, but I would say in the last 5 years, the legislature in Illinois has turned divorce and family law on its head. They've gotten rid of the word custody. They've gotten rid of the word visitation. They changed the formulas for both maintenance, which used to be called alimony, as well as child support. So what are they trying to do here?
Well, the Illinois Marriage and Dissolution of Marriage Act, they have changed it. There are other states that have similar models, and so the whole thought. Let's go back to, and I believe that was 2016, is when they changed it. It's no longer custody and visitation. But let's be honest here, okay? Everybody is going to look at it as custody and visitation because it's very, very similar. Now it's the allocation of parental rights and responsibilities, broken into two prongs. One is parenting time, and one is decision making. Parenting time is, or formerly visitation, right? And decision making covers 4 areas. It covers religion, it covers medical, it covers education and extracurricular activities. And any one of those 4 areas can be jointly made, can be solely made, or it could be any combination.
So if one parent has decision making over extracurricular, that person could say, Johnny's not going to play football.
If that person has sole decision maker, right, but then that's what's going to happen is the parties are going to be back in court. But yeah, it can be in those areas, and that's true.
Okay.
So that's the.
But what's the point of all this? Why turn everything up on its head here? What's the reason?
Well, again, like many things, other states are doing something, but the deal is this: that people, it's really not about the husband and wife so much, really, as it's about the children. And the reason for that is I talked to a lot of people before we had joint custody and sole custody. And joint custody was the non-custodial parent had a joint say-so in those areas that we've talked about. And sole custody was that the non-custodial parent, the person who didn't have the child most of the time, did not have a say-so. And a lot of times the party and the wife or soon-to-be ex didn't want the husband to have a say-so or vice versa or whatever, and the husband is thinking, hey, look, you know what, I'm losing all my rights, which isn't true. It's just those areas, and generally they probably haven't exercised them anyway. But what this does is it lightens it up, okay? And even in Illinois too, now there are, you remember what the grounds used to be, Dave? What were the grounds for divorce before?
Oh, there were several. Physical cruelty, mental cruelty, adultery, habitual drunkenness, desertion, irreconcilable differences.
And now, and before irreconcilable differences was the no fault, and you had to wait 2 years. Actually, that was the living separate and apart, but you could waive most of that except for 6 months. Now, Illinois, the only ground is irreconcilable differences, and it's just 6 months that you have to have been living separate and apart. Doesn't necessarily mean living separate and apart. Could be that you're no longer living as husband and wife, although you're living in the same house. Could be one party's living in the guest bedroom or the basement or the attic. Could be even they're still living or sleeping in the same bed, but they're no longer intimate. They're no longer acting as husband and wife. So that's changed too, and the reason is because, hey, it doesn't matter what people do that way. And again, a lot of other states have this, and so it's kind of to lighten it up and to, I guess, really to update it. Some people like it, some people don't, but the bottom line is it is what it is, and this is where we're at, and so, hey, you just need to make the best of it. in any event, a divorce is a death of a relationship.
Right. All right. Speaking of death, let's move to probate. When does someone have to probate an estate?
Well, a lot of times, if anybody, there's the testate and intestate. Testate means the person passed with a will, intestate without a will. If somebody passed away with a will, you have to file it, I believe it's within 30 days, I think, in the county that you're at. Even if you don't do anything, it just has to be filed. Doesn't mean that the estate is going to be, go through probate. So let's say my wife and I, something happens to me. All right, still has to file the will, but hey, everything is in joint tenancy. So joint tenancy means if the other person passes, everything goes to the other person. With right of survivorship, so it doesn't get probated. You have the issue where if you do have to do it, let's say it's a parent that passed away, and as long as their estate isn't over $100,000, you can do a small estate affidavit, and there's really no property, which is a document that can be completed, and you would give it to the bank, wherever that is, and you'd be on the hook, obviously, you're telling the truth, and that's true whether or not they have a will. But when it goes beyond that and there's property and things involved, then you have to file your petition with the probate court, and then you also have to establish the heirs and the legatees. There's a difference between heirs and legatees. Heirs are people who are offspring of the people who have passed, and legatees are people who inherit. So maybe I'm giving money to my friend. Okay, he's not
He's not an
offspring
heir.
or anything, right? He's a legatee, and so those things have to happen. There has to be a published notice in the paper, and that has to be published, I think, 3 or 4 weeks in a row, and you really can't close the estate until after 6 months since the publication, so that all of the creditors or potential legatees or heirs or whatever get notice to be able to do that.
Okay. Do you need an attorney to do this, or can you do it pro se?
You can do anything pro se. However, I would certainly get an attorney who does probate. What's going to happen, and if it's a simple thing, even if it's a simple thing, it's quite difficult. It would sort of be like me trying to work on my car. Now, hey, back in the day when you could actually lift up the hood and you didn't see the flux capacitor, okay, you could work on your car. You could change the alternator. Now you lift it up and it's just, there's just no way. And so it'd be the same thing. It would be a wise thing to seek counsel.
Okay. Let's move it on to traffic now. Let's talk about some changes with regard to DUI. Those have changed over the years too.
DUI certainly has changed since we started practicing, Dave. It's really, especially it's misdemeanor depending upon what happens. You still have the same kind of issues in terms of the legal limit. 0.08 is the legal limit, and there's 2 statutes per se, and impairment. Impairment, obviously, it doesn't matter what you've blown if you're impaired, and that's true, for example, if somebody is on any other intoxicants like maybe marijuana. And now, actually, that's probably something very good to that people should know, because as the laws become more lax and as people are not being criminally prosecuted for possessing and for ingesting small amounts of cannabis, it would still be a DUI, driving under the influence, if they ingested that cannabis and they drove with it in their system. The same is also true of prescription opioid medication as well. That can be an issue. And again, that's the impairment, and the other one is over the legal limit of 0.08. And nowadays you have the device that goes in your car to be able to drive after you get your summary suspension.
Let's talk about a first-time offender. Let's go through some of the time frames and what that first-time offender is going to be required to do to reestablish the license.
46 days, license is going to be suspended, and then what you're going to have to do is you're going to have to bring your car in, and it's going to have to be fitted.
On a first-time offense?
Used to do a summary suspension, right? A motion to to suppress that, right? There's two things. So understand, whenever you deal with the rescission of the summary suspension, that's civil, and then the criminal, the underlying DUI, is criminal. So there's two different standards of proof. In the law, we have three different standards of proof, okay? So let's take it from, we have civil, which is more likely than not, a little bit more than 50%, okay? And then on the criminal side, it's beyond a reasonable doubt, not beyond all doubt, but beyond a reasonable doubt. And then in the middle is clear and convincing, which is difficult to achieve. The rescission is a civil matter, so that's by a preponderance. You have to establish any one of those things in the statute in terms of
that maybe the stop was not valid.
Well, right. But I mean, you also generally what happens too is a lot of times they'll do a motion to suppress, contesting the legitimacy of the stop and everything else. And nowadays, when there's cameras everywhere, and even supposed to be body cameras, that's either good or bad for you, depending upon what you do. You don't have to blow when they stop you. You don't have to do the field sobriety tests. They kind of sometimes scare you into it. And you really shouldn't be driving intoxicated. It's much cheaper to take the Uber or the cab or to just get a hotel. Okay. That's what I've told my nephews and great nephews and such. And so that's really bad. But when you do it, I mean, gee, if you blow or if you say you were drinking or anything else, then you're really not allowing much room for anything, maybe other than a plea.
Okay, so after the 46 days, if you don't rescind the summary suspension,
well,
you can't drive.
Right, but that you can get, and it used to be, you used to get your employment, kind of a restricted driving permit.
Judicial driving permit.
Right, but now
to and from work.
Right, but now it's different. Okay, now the law has changed in that respect with doing all of that, and so basically you go to the Secretary of State and you get the device that goes into your car, and where you have to blow into it, and again, obviously there's gonna.
How long is that for?
Well, you're gonna have to pay for it, and there's a monthly expense. But here's the deal: if you blow into it during that period of time that your case and everything is going on, right, and you are intoxicated, the Secretary of State does have the authority to, to clip your wings. So
who would be foolish enough to do that?
There are a lot of foolish people out there, Dave. They're just better off not to. Well, there are people who don't have a driver's license because it was suspended for pick a reason, but they still drive. I get it. I understand it. They have to get to work, but hey, a lot of people that take the bus and everything else.
Other than disabling the vehicle, they can't add to the sentence, correct?
And again, other than your suspension of your driver's license.
Okay.
Right. Let's talk about something that is really more prone to the people at home, which is just a regular garden variety traffic ticket.
Sure. Well, it used to be, back in the day, if you had counsel and it wasn't a terrible incident, or if you weren't speeding 120 in a 55, you'd be able to get supervision. That's escalated now to school, court fines, another way to make money for the county and the state.
Well, yes and no. You have a lot of people who do, a lot of people have a heavy foot. And especially if it's a young teenager or somebody like that, that's something they ought not to be doing, especially if they have a nice, a quick sports car. And so traffic school is to kind of explain the dangers and everything else, because realistically, I think probably the biggest danger now, even bigger than DUI, and I'm not sure about that, but I'm just kind of gleaning a little bit from that, is the devices now that people are texting and everything else. It's just like like drunk driving.
It's worse.
Yeah, it's because you're not paying attention. You're not, and I see that all the time when I'm on the road, on the expressway. There's somebody behind me. I see them looking down. I cringe. I've worked really hard, so I don't do that. And besides my car, I could just press a button, it reads it to me. And then I'll go to the next lane, thinking I got away from that person, and then there's somebody behind me doing the same thing. And so that's really, really difficult. There's a lot of lives lost because people don't pay that attention. And all of a sudden, it's really quick that traffic can come to a quick stop. and boom, and it's all over. Or, God forbid, a motorcycle, you hit a motorcycle or something else like that, and it's just, I don't know what the answer is there.
Are you seeing a lot of tickets for people driving with devices?
I don't think that they ticket enough. And I say that because it's illegal in the state of Illinois to talk while you're driving on your phone without a Bluetooth device. And you see it all the time. I guess there's not a cop around when you need one for that respect. But it's really, really because of the way technology has developed. And I'm sure they'll come up with some kind of a solution. Maybe there'll be some kind of jammer in the car. So I don't know.
What about the civil penalties, though? Have you seen those increase to the point where it really is cost prohibitive to speed?
No, I think that, again, if you go in with an attorney, you can generally, of course, you're going to have to pay your attorney too, and it's always better to go in with somebody than not. If you're really a first-time offender, you're not a teenager, you're not under 21, you could probably send the ticket in. Sometimes it gives you an opportunity to do that, but you want to make sure that you do get supervision. Supervision is technically not a conviction. Basically, supervision means that, hey, as long as you complete the duration of your sentence, however long that's going to be, 30 days, 60 days, 90 days, whatever, without another incident, then technically it gets dismissed. It's still there, but it's not a conviction for purposes of anything else. For example, your insurance rates or anything like that.
Yeah. The prosecutors can see that prior supervision.
Oh, they have everything. Don't even try to go up and say that you haven't had. They have your whole history, a whole printout. If you ever wondered what that stack of stuff is, they know what you. And so the judges. It used to be, Dave, back in the day when you'd go to Cook County and you'd do a ticket there, then you'd go to DuPage County and you'd get the supervision there because there is no.
They didn't reference it together.
Well, they didn't reference it together. There was no network or anything else, and now, just not going to happen.
Okay. So slow down is what you're saying.
Yeah.
Slow down the spending, too. Let's talk about Chapter 7. These are for people who are over their head with credit cards, medical bills, personal loans.
Who's primed for a first start, Dave?
Well, anybody. Anybody who needs a fresh start, who's over their head and can't pay their bills and can't get out of debt. And if it's going to take 3 to 6 months and you're not going to get anywhere with your balances, then it's something you need to look into.
How much over your head? What would be the threshold?
Really depends on the person. For some people, 5,000, 10,000. For other people, it's 25 or 50. Depends on what you're making, what you're spending, your household size, where you live, your lot in life, whether you're working or not. There's a number of different factors. Whether your license is suspended for parking tickets or child support, that would lead to a Chapter 13 reorganization to save the license.
Is that going to get my, if I do a Chapter 13, is that going to get my driver's license back for child support?
Well, if you're reorganizing through Chapter 13, you can bring a motion to have your license reinstated as long as you're repaying your child support.
At what the bankruptcy court says or what the divorce court says?
No, you'd have to bring it into the bankruptcy court and bring the motion there. The divorce court might have suspended it, so the Secretary of State has a suspension on file from the family law court, but the bankruptcy court is actually going to make that decision when the attorney brings a motion to reinstitute the license while they're in this repayment plan. Because Chapter 13 is a 3 to 5 year payment plan. So you are making an effort to repay all of your child support arrears over that 5-year period.
So for that instance, it would have to be a Chapter 13. So switch back to the Chapter 7. So it just depends. How would somebody get started? Hey, I decide that, look, you know what? I can't pay this anymore. I've been using one credit card to pay the other one off, and then using that credit card to pay this one off, and back and forth and back and forth. I'm just tired. I'm getting stressed out here.
Well, the first thing to do is do a little research online and find out a little bit more information just in general about bankruptcy and what it offers, and then seek out the right counsel. Again, look for someone who practices in that area, who has knowledge, and then make an appointment. Most attorneys will give a free initial consultation as it relates to bankruptcy. Not other areas, but bankruptcy.
Well, what kind of information am I going to be required to bring?
Well, you have to bring all the information with regard to who you owe money to. You also have to bring proof of income. So if you're working, bring a paycheck stub. And it would be also helpful if you had a tax return as well, but it's not required for the initial visit. You just really want to bring yourself, proof of income, and a list of who you owe.
Well, let me ask you this. What happens if my income is staggered? It's not consistent.
Yeah, you're just going to estimate that. You're going to take a 6-month average, a 3-month average. You want to be able to tell the attorney approximately what you're making. It doesn't have to be to the dollar.
And how long does it take from start to finish? Let's say I have the consultation with you now. I'm a candidate to be able to do that, and come this Monday coming up here, you're going to have everything completed to file.
Well, if you really want to move quickly, from filing until completion is about 110 days. And within that time frame, you're going to go to one court date about 4 to 6 weeks after filing. And then you're just going to wait for your discharge to come in the mail.
I'm kind of worried. What kind of court date? Is there going to be other people there? Am I going to be in front of the judge? Is he going to question me? What's going to happen?
You're going to meet in front of a trustee with your attorney by your side.
Who's the trustee?
Trustee is the person appointed by the bankruptcy court, or the U.S. trustee's office rather, to oversee the case, to administer the case, to see if there's any assets that can be taken and sold. But in 95% of all Chapter 7 Fresh Start cases, there are no assets that are taken. The individual who's filing bankruptcy gets to keep their property free and clear, as long as they're making payments on secured items like a car or a house.
Are there going to be creditors there when I go to talk to the trustee?
There may be a creditor there, but typically not. For the most part, the trustee is going to do his or her job independent of any creditor input. And really, the meeting is quite simple. If your attorney has prepared you well, and if you've been honest, you're just going to answer a series of yes/no questions under oath to convince the trustee that there is nothing to be administered. That's really the whole point of the meeting.
Is there a threshold of income that I could make that would exclude me from doing a Chapter 7?
Yeah, if you're making too much money, you can't do a Chapter 7. There's something called a means test, which is based on IRS standards, based on median income for family size.
Oh, that's great, Dave, because here, I only make $25,000. My wife is the one who makes $150,000, so we're good to go with my $25,000. You put that in there, or we should be in business.
No.
What do you mean, no?
Not the case anymore.
What are you talking about?
You and your wife are a partnership. You are a household
Well, that depends
income.
on who you ask.
Well, if you're not separated, the whole thing gets
Okay.
factored together.
Separated like how, Dave?
Well, you have to be in separate households, or separated within the same household but not functioning properly as husband and wife.
Okay, so what I understand you to say is that they're going to take into account the total family income?
That's correct, because they're looking at the total household income. So if you had a adult child living in the house who was bringing in money, technically the court can say, we're going to factor in that person's income. This is, again, the government is all involved in this. They're all encompassing. They're going to look at your income. They're going to look at your expenses. They're going to see whether or not you have higher expenses than the national average and what the IRS allows. And if they feel that you have the ability to repay a portion of your debt over time, you're going to be forced to do a Chapter 13, or they'll just dismiss your Chapter 7 outright.
And then that's the end of that story.
Well, then the creditors are back at the door again. The wolf is at the door.
Wow. Well, here, let me ask you this. Let me ask you this interplay. What happens if I'm getting divorced? And is it better for me to file it before or after? Or what if I'm just going to wait because hey, I'm the guy, I'm always going to have a bad deal here, and I get strapped with all of the income, and then, or rather all of the debts. And so after the divorce, I'm just going to file bankruptcy. The heck with her.
Well, it depends on what you have together as a couple in terms of debt as well.
Oh, this is all joint debt from the marriage.
All right, well, I would wait till after the divorce to file. Because if you file early, the divorce decree can still say you're responsible for some of the debt that you just discharged in bankruptcy because it's a joint debt, and they're going to come after your ex-wife. So I would wait until all the dust settles in the divorce case to make a determination of whether you can file, what you should file, and what you may be responsible for because of what the divorce decree says.
What if we're in agreement and we're both going to file? Then that would be okay anytime, right?
If you're both going to file, I would file while you're still married, because you can do that under one case, one filing fee, one attorney. Make it simple on yourself.
Well, let me ask you this. So let's say in the divorce case here, to just mix it up a little bit, I am required to pay back $20,000 in joint marital debt, and she's required to pay back the same thing because it's down the middle here. All right, and so it's joint. They're in both of our names. Okay, and so after the divorce is over, I do a bankruptcy. Well, now the creditors can't touch me for that. What can she do to get me in trouble, taking me back into the divorce court?
Well, she can bring a rule to show cause why you should not be held in contempt because you haven't honored the divorce decree. Bankruptcy doesn't get you out of the underlying debt awarded in a divorce decree. So you have to be careful there. So it makes a lot more sense to wait and see what's going to be ordered and what's not going to be ordered. If you can. If not, then you file orderly. But if you can wait, it's in your best interest to do so.
So basically, afterwards, I can discharge anything or get discharged anything that's just solely in my name that was awarded to me in terms of debt-wise, not that is joint where her name's attached to that.
Right. The best thing to do is to stay together.
Okay, well, here.
Try not to get a divorce.
That's a novel idea, Dave. How about that?
Yeah. But if you have to, if you've tried to fix it and it hasn't worked, you know you can go to the courts and, with the grounds of irreconcilable differences, dissolve the marriage. Now, that could lead to a whole set of problems in litigation, aside from a bankruptcy filing, but that's the way it goes. We just have a couple minutes left, Jesse.
Okay.
I want to talk to you real briefly about a new kind of area that you've been doing, which is the mediation. Talk about mediation.
Been doing that for a while. Been mediator in DuPage for a while here, and basically mediation is it's required in divorce cases or family law cases where there's an issue with, I'm going to say it, visitation and custody, but it's not. It's the allocation of parental rights and responsibilities, or if it is a relocation case, formerly called a removal case. And so the mediator, the parties get sent to the mediator, and the mediator is an independent person, an attorney with training, who is not partial to either side, doesn't know either side, and that person's job is to try to help the parties come to an agreement. And so the mediator is in charge of the process, and the parties are in charge, responsible for the outcome. So, but you really have to go into mediation with an eye toward really trying to resolve it. A lot of times, there's three possible outcomes: no agreement on anything, complete agreement on everything, or someplace in between, which is okay too, because now you've just saved a ton of money. Instead of litigating these other things, then you've narrowed it down to just a couple of issues.
Is your mediation report admissible in court? Is it made part of the judgment? How does that work?
No, what's going to happen, and in fact there's an agreement that that's not going to happen, that I'm not going to be called, or the report. What I'm going to do, and I'm just going to send the court a form that says, hey, the parties mediated on this date. There's a statistical form that talks about how much what the cost was, how many hours, whether or not there was an agreement or not an agreement, and really that's about it. If there is an agreement or there's not an agreement, I'm going to send a letter to the parties' attorneys that's going to outline the agreement. Generally, mediation is only involving the allocation of parental rights and responsibilities. It doesn't involve monetary issues. You could do private mediation that could take care of the whole deal. Pretty much trying to go through the divorce before you file anything to just go in there with an agreement.
What about clergy?
What about clergy?
Can they do mediation as well for the couple?
Not this kind of mediation. They could do mediation in terms of, hey, trying to get your marriage back on the rocks, but in terms of, actually, anybody who has the training and who's approved by the circuit court, depending upon where you're at, can do it. You don't necessarily have to be an attorney, but most of the mediators are. There are some psychologists and some other people there as well, but it's really important to try to really work it out yourselves.
Okay. Thank you, Jesse. Sounds good. Great seeing you.
You too, Dave.
Okay. We'll see you next time on Legal Action. Take care.